Section 1194. 2b. Chemical test refusal. Police in New York routinely request chemical tests of blood, breath, urine, or saliva after a drunk driving arrest. Though some people assume they can decline, New York's implied consent law means every licensed driver has already agreed to testing. Turning down a request triggers serious consequences that are separate from the criminal charge. Understanding what Section 1194, 2b, requires and the penalties it authorizes helps drivers navigate a stressful situation and make informed decisions. New York Vehicle and Traffic Law Section 1194, 2b, codifies implied consent. It states that anyone driving on public roads is deemed to have consented to a chemical test when lawfully arrested for driving while intoxicated. Officers must have probable cause for the arrest and must clearly warn the driver that refusal will result in license suspension and revocation. If those conditions are met and the driver still declines, administrative penalties apply even if the criminal case ends in an acquittal. The purpose of this statute is to secure evidence and protect public safety. A refusal can be explicit, such as saying no, or implicit when a person remains silent or does not cooperate. After observing signs of intoxication and conducting field sobriety checks, officers ask for a sample. Drivers may consult with an attorney, but any delay that causes the testing opportunity to expire is treated as a refusal. An officer's duties include explaining the consequences and documenting the refusal. Immediate penalties begin at arraignment. The judge suspends the license based on the officer's report. There is no provisional or hardship license while awaiting a Department of Motor Vehicles hearing, which is usually set within 2 weeks to decide whether the suspension becomes a revocation. At that hearing, the administrative law judge must find, by a preponderance of the evidence, that the arrest was lawful, the driver was warned, and the test was refused. If any element is not proven, the license is reinstated. Refusing a first test can bring a license revocation of at least 1 year, along with civil fines and additional assessments. Penalties increase for people with prior drunk driving or refusal incidents within 5 years. Drivers under 21 also risk extended license loss. During revocation, no conditional license is available, and driving can lead to criminal charges. Refusal stays on a driving record for 5 years and may lead insurers to increase premiums or cancel policies, while repeat incidents can cause the DMV to deny relicensing. These sanctions apply even if the criminal case is dismissed. The hearing is separate from the criminal DWI case and is held at a DMV office. If the arresting officer fails to appear, it may be adjourned once before proceeding without the officer. Drivers may subpoena the officer to ensure attendance. Although administrative or court appeals exist, they are difficult to win, so appearing with a lawyer is important. Drivers can challenge the legality of the stop or arrest. If officers lacked probable cause, the refusal may be dismissed. Warnings must be clear and comprehensible, and proof that a person tried to cooperate but could not because of a medical condition or misunderstanding may undercut the charge. Cross-examining the officer can reveal inconsistencies, and procedural errors such as an absent officer or missing paperwork can warrant dismissal. Courts also recognize a limited right to consult a lawyer that cannot delay the test, which underscores the value of representation. Chemical test refusals impose serious penalties, but informed drivers are not without options. Knowing the law, understanding the DMV's burden of proof, and working with a competent lawyer can help reduce the impact. The Kugel Law Firm explains that chemical test refusals led to immediate suspension, potential revocation, civil fines, and increased insurance risks. With proper legal strategy, it may be possible to challenge the refusal or lessen its consequences. If you are facing a refusal hearing or related drunk driving charge, contact the Kugel Law Firm at 212-372-7218. The firm's office at 111 E 125th Street 2nd FL, New York, New York, 10035 offers guidance and representation throughout the process.